Everybody, it's 2 o'clock on the nose, so we're going to get started. There'll probably be some other people joining us, but they'll catch up to us as they join. Welcome to the part of the presentation that deals with crypto contagion, the world of crypto bankruptcies. This is part of my law firm, Greenberg Glusker's CLE Last Dash series, one of 6 in our series, and this is the 3rd year that we've been hosting it, so welcome. I'd like to briefly introduce my 2 partners that have joined me on this program. First, let me introduce Peter Jackson. Peter is part of our IP group, and Peter's focus is on complex transactions involving intellectual property and privacy issues. And Peter will be talking to us about that aspect of the program today, giving us some understanding of how crypto works and how digital currencies work. My other partner, Jonathan Shenson, who like me is a bankruptcy lawyer. Jonathan's practice involves the representation of debtors, secured creditors, parties acquiring assets out of bankruptcy, and various other parties in bankruptcy situations. Together with Jonathan, I also work in the practice area of bankruptcy, and most of my representation tends to be of debtors, but having practiced in this area for about 40 years, I've represented all the different constituent interests in a bankruptcy case. Let me just get some of the formalities out of the way. First of all, there are a number of people from different walks of life that have joined us today. So some of the topics that we cover may be mundane to you, well, hopefully not mundane, but maybe known to you. And new to others. In other areas, topics that we cover may be entirely new to you, so bear with us to the extent that the topic is something that you already have a reasonable understanding about. The second point I want to cover is that this is eligible for continuing legal education. There will be placed in the chat the CLE information, and we will also follow up by way of subsequent email with the CLE criteria, the qualifications. And then finally, I wanted to mention that to the extent that we have time, we will try to take questions as we go along. Please use the Q&A portal. There is no chat portal that's been disabled for this webinar, but use the Q&A portal to ask a question. We'll be watching for questions, and we'll try to answer them as we go along. So the program is going to cover 3 general areas. First of all, Peter Jackson will talk about blockchain and some of the terminology and give us some better understanding about that business so that we can better understand how to apply it to the legal issues that we need to deal with. Jonathan will then get into some of the issues that are ongoing in today's bankruptcy cases and give us some further insight into that. And then I'm going to end the program in talking about pending legislation, both on a federal and state level, and also the proposed changes to the Uniform Commercial Code. So with that, let me turn it over to Peter.
Hey, good afternoon, everybody. I'm going to go through just some what are to me, not that perhaps mundane concepts, but they'll be helpful, hopefully, going forward for everybody as we discuss how these map to bankruptcy issues. So we're just going to really quickly talk about what a blockchain is. Fundamentally, it's a list of records. And typically, it's called a blockchain because the data records are compressed into blocks. And what I've done here on the right, what you're seeing is explored a little bit of how Ethereum's blockchain can be viewed as a user. And you can see how these transactions are compressed and the contents of what's happening therein. So this is etherscan.io. Typically, a blockchain is decentralized, which means it's maintained by individuals or businesses who want to participate in its ongoing infrastructure. Typically, you're rewarded for doing so in the form of currency that is the transaction mechanism for the blockchain, which we're going to get to in a second. The idea here is that it's going to be a permanent and immutable record. It can't change, and no one no one can alter it in the future. And you can look back through time at everything that's happened on it in perpetuity. With that, hopefully that's enough table setting. We're going to go into some other topics. Tokens versus coins. I'm not sure how relevant this is, so I'm going to speed through it a bit, relevant to the bankruptcy issues in any event. But I think it's worth noting that typically when people talk about coins, this is a blockchain specific instrument that is used to write a transaction or is the mechanism of transaction on a particular blockchain. And you can think of this as acting somewhat like a fiat currency in a specific financial system, like dollars in the United States. So with respect to Ethereum, which we just saw, all those transactions that are occurring to be written onto the blockchain, Ethereum's native token, ETH, or Ether, as people call it, or I've called it ETH on here, is spent by the person who wants to write the transaction or maintain the record of information. By contrast, a token is a digital unit of value that is not necessarily blockchain specific. It could go across, it could exist on multiple blockchains, and or you could have the same sort of unit of value on multiple blockchains. We'll come to this in a bit more detail when we discuss stablecoins, which are an interesting topic, but this would encompass things like NFTs, which you've probably heard of, and which you can see on the right of the screen, which is an NFT that's maintained on Ethereum. NFTs can be maintained on a variety of other blockchains as well. And then there's also been instances where tokens have migrated from one chain to another. An example is Binance being the sort of largest crypto exchange in the world, and now that FTX has bitten the dust, and it originally had its unit of transaction on the Ethereum blockchain before launching its own proprietary chain and moving it off of Ethereum. With that, I'm going to go to stablecoins, which are kind of a hybrid of those two things. But the idea here is that this is an instrument of value that is pegged to a fiat currency at a fixed rate. So as an example, we can think of $1 as being equal to 1 USDC. That is a common stablecoin. It's not the largest by value, it's the second largest, but it is an incredibly commonly used instrument of exchange. And typically people think of, when they say USDC, they're thinking of the Ethereum version of USDC, but in fact, the issuer of this token is a company called Circle, and I've done a screenshot from their website at right. And USDC actually exists on multiple chains, and the dollars that back USDC are, not specific to a particular exchange. They're there to back the total free float of USDC in circulation, as we'll come to in a moment. I wish I could pause for questions, but I'm just going to keep going. So, with stable coins, as with all of these instruments, the question of trust comes into place. Why do you believe that 1 USDC is worth $1? And, as with all of the topics that I've just discussed, these are not legal definitions so much as nomenclature that is commonly used by participants in this industry, ecosystem, whatever you want to call it. There's no real regulation of stablecoins today as just a general matter. And in fact, the sort of crypto contagion that we're talking about today was teed off by a run on what I'll just call a fake stablecoin, which was this coin that was called Terra, that was supposedly backed by the corresponding value of another token instead of by dollar reserves or euro reserves or something like that. And when that ecosystem lost its peg because people no longer believed that there was enough of the sibling token Luna to back Terra, you saw a lot of value ride out, and a lot of contracts that were based on the value, were denominated in and or relied on the value of Terra became unstable, and that has reverberated through the entire crypto ecosystem, markets ever since. I think that was May of last year. In any event, the larger issuers of stablecoins are now doing a bit more to disclose their actual dollar backings. Right, you can see from Circle the page where they show their monthly attestations from an auditor. Maybe not one that maybe not one of the big four. I think they've been trying but haven't succeeded to get an accounting firm like in that echelon to audit this stuff. But you can see that at the this was from November 2022, which is the most recent one available as of the creation of this presentation. There was $43 billion worth of US dollars in custody accounts, and there were about the same number of USDC in circulation. And finally, I think as Brian's going to talk about perhaps a little bit more later, we're seeing governments sort of get into this space where the creation of a digital equivalent of the fiat unit of currency in a particular nation or state is paralleled or recreated in a stablecoin variant. The Australian government most recently has been exploring this, and there's actually efforts at the Federal Reserve to sort of explore that in the United States as well. So that may be a future that we will one day be in. Okay, so with respect to wallets and accounts, this is actually quite relevant to today's topics that we're going to get to when it comes to the bankruptcy issues. This concept is kind of esoteric and hard to understand, but ultimately what we're talking about here is when you're interacting with cryptocurrency or tokens, who's in control of it? Is it you as the user, or is it someone else? And I'll just remind everyone of the adage that the old time crypto enthusiasts will tell you, which is not your keys, not your crypto. And that's because blockchain entries are associated with particular blockchain addresses, and controlling those addresses is done through a private key, which only the holder of that key can execute, or anyone else who has it. So when you create a wallet, such as you're seeing in the steps at the right with MetaMask, you are just asked to put in a password, and there's no username. And that is because MetaMask is actually going to create a new Ethereum address for you and store sort of the secret code that explains what that is locally on your device where you create it. That may be if you use Chrome, like a browser extension. You could also have that information put into a hardware wallet like this ledger that I have here. And so MetaMask is a easy way for someone who's not necessarily the most technically conversant person in the world to create a wallet, a software wallet. And this will be contrasted later with what happens when you create a user account like you might have with Google or Microsoft, which has, which is ultimately controlled by a third, the entity that provides the account details itself. So yeah, no username here. I'm going to briefly go through how a private key is created because I think it's worth understanding. You get this, what you get as the user when you want to, be able to log into your account later and use it on a different device is this 12-word sequence that's randomly generated. It actually corresponds to values in a numerical list that dates back to the early days of Bitcoin. And when you put all those numbers into a list and then do some math on it, you end up with a private key that controls the blockchain address that was created for you. And using that address, you can derive the public, using the private key, you can derive the public address of that particular individual on the blockchain. And I've used the shortened version here. I actually created this one a few days ago for purposes of this presentation. It's null, but nevertheless, that one at the bottom right is what you can associate with yourself and tell your friends about. And then the one on the left is the one that controls the assets itself. So this is just an explanation of that. Interactions with the public key are for the world, but only one person should have the private key that allows you to control the actual assets that are within that that are associated with that particular account on a blockchain. So yeah, if your friend wants to send you a movie ticket or you want to record a security interest in something, you would just do that by sending it or interacting with it at the public address, and the private chain, the private key is for purposes of controlling the actual stuff that's associated with that account and address. By contrast, so we talked about MetaMask, that's creating a cryptocurrency wallet software basis. Coinbase, which is perhaps the most regulated participant in this ecosystem as a US public company, has kind of two types of accounts. The vanilla type of account you might create is similar to creating any other type of financial account. It's that flow you see at the right, and you'll be asked for your name, bunch of KYC information, etc., email, password. And what happens when you start using one of those accounts is that you can bring in some fiat currency, perhaps through connecting a bank account, maybe you buy some Bitcoin with it. All of those assets are not stored or associated with a particular blockchain address. They're actually stored by Coinbase kind of on a fluid basis, or at least they were as of this change, which I'm going to note here in the user agreement that applies to them. By contrast, Coinbase also offers something very similar to what we just described with MetaMask, which is more of a wallet account in which the assets are segregated and are associated with a particular blockchain address to be held by you. In pertinent part here, just some quotations from the user agreement as it was changed actually early last year at this point, but you can see that the assets in a traditional Coinbase account are not segregated. They are custodial assets according to the terms, but if you custody your digital assets with Coinbase, Coinbase retains control over the electronic private keys associated with not just one blockchain address because you don't have your own, but the blockchain addresses that include those that have your assets. So they're not segregated by nature. They're commingled, and they're supposedly in a custodial arrangement nevertheless, but you do not get a private key if you create a vanilla Coinbase account. Okay, we just talked about the Coinbase terms, so I'm going to briefly touch on, because it comes up later, the idea of the enforceability of online user agreements or online contracts in general. Apparently, this is of as someone who practices in this space all the time, and who most of my clients, use online contracts exclusively, it continues to surprise me that there is sort of shock and awe at the fact that these are enforceable. They are, as long as there's been sufficient notice to the particular user of the existence of the terms, and they've had an opportunity, and there's a record that they've assented to them in some way. So we'll go through an example of where that wasn't true, and we'll go through an example of where that was held to be true. At right, and I apologize for the poor reproduction, but it comes from a court case from late 2021. You'll see that justanswer.com had put its applicable terms of service below the button where a new user would action creation of an account and be bound to the terms. It's very hard to see. And I think that the most important thing to understand here is that regardless of the state where you're in the United States, or the applicable law and the terms that are used, inquiry notice, constructive notice, etc., this is ultimately a flexible exercise that comes down to sort of a reasonable person standard ultimately. And what you end up seeing courts do is look at how conspicuous the notice was and how meaningful the opportunity for the user to assent was, or understand what they were going to be bound by. And I guess I'll say that you do not need in any state to have read the terms. You just need to have known that they existed, had an opportunity to read them. And so here, because they were underneath this action button, they really weren't that visible to users, and the terms of service below were held to be unenforceable by a California court. What I tell clients is put a tick box and log the person's interaction with the tick box above the button where they create an account or agree to an agreement, and make sure it's quite clear what it is, and obviously include a link to it if you're not going to display the whole thing on the page. And you can see that was done here. The terms of service barely underlined in that white text, but not great. And finally, the reference, it should be clear that these are contractual in nature, that you're agreeing to something, not just that terms apply, for example. So an example that comes up later, which we're going to talk about in some more depth because it comes from a bankruptcy case, is the Celsius exchange, which was you guys will tell me where we are in the bankruptcy process. I don't know how to refer to things. But anyway, Celsius had online user agreements, just like we saw with Coinbase earlier, and was in the position of needing to prove the existence of the contract. And what they were able to put forth, and these are screenshots from a court filing from not so long ago, is all the evidence that users had agreed to versions of the terms of use that governed the Celsius accounts that those users created. And so, right, you can see sort of the tick boxes where a person who's creating a new account would agree to these things. You can read all of it. It shows exactly what the changes are. This is actually a really robust example and is prudent given that there's a significant amount of money involved for most users. And then you can see what happens if you were an existing user and new terms were coming into effect at the bottom. And finally, the logs that Celsius was able to provide showed that 90% of account holders on the website had accepted terms of use version 6 or later, which is pretty good. And some websites do not do a great job maintaining logs, but it's important if you want to prove the existence of a contract. And with that, I think that we are ready to move on to Jonathan. So thank you all.
Thanks, Peter.
Thanks, Peter. So as you are all, I'm sure, very aware, we've had an onslaught of crypto-related bankruptcies over the last year. And for those that are not as familiar with bankruptcy, let me just sort of lead into the topics we're going to get to with sort of a quick overview of some of the key concepts and terms that we'll be referring to as we proceed through this portion of the program. And let's just use a crypto exchange as our working example. When a crypto exchange files for bankruptcy, an automatic stay is the result of that filing, such that any actions that were commenced prior to the bankruptcy filing by creditors and other parties in interest against the debtor, in this case, the exchange, any effort to exercise control over the debtor's or the exchange's property, and importantly, even property that is in the hands of or under the control of the debtor, even if it's not property of the debtor's estate, is all subject to an automatic stay, such that the creditors and other parties in interest can't proceed against the debtor or the property absent relief and a court order from the bankruptcy court. Working from the same exchange concept, typically, and in the main, exchanges are often platforms in which customers will make deposits of either fiat currency or cryptocurrency with the platform. When it's a true exchange, it may be on there for any number of reasons. It may be a place for the customer to simply have its cryptocurrency held. It may be a platform in which the customer seeks to trade or acquire crypto with fiat currency. In other instances where an exchange may have other products, such as earn or reward accounts, which are essentially arrangements in which a customer might make a deposit of cryptocurrency, and the exchange or lending platform may provide for a yield, effectively interest on the crypto assets that will accrue, and the terms upon which it will accrue, and whether it is in perpetuity or for a stated term, and how much, are various ways in which the customer can make available its cryptocurrency to the exchange, which enables the exchange or the lending platform to use that cryptocurrency for its own purposes to indeed obtain yield that ideally will be greater than that which they promised the customers, so they will make a profit. So one of the key and really interesting questions that has come out of these cryptocurrency bankruptcy cases involving exchanges and lending platforms is when a customer makes a deposit or deposits crypto assets with an exchange, what are the rights of the customer as opposed to the exchange with respect to that crypto asset? If the crypto asset is deposited with the exchange, is it still the property of the customer, or has the customer agreed to transfer its rights, title, and interest in that crypto asset to the exchange? We'll get to in a moment the various issues and ways in which you have to look at the issue to at least get some sense on how it will be treated ultimately. But the implications are also worth going through on the front end, because it's a material difference in terms of what a customer will likely expect to receive from the bankruptcy estate, ultimately, depending upon whether it is property of the debtor's bankruptcy estate, the crypto, in other words, it's now the exchange's asset, versus the customer retaining its right, title, and interest in that crypto asset. If it is determined ultimately that the crypto asset is property of the exchange's bankruptcy estate, then the customer is essentially left with a claim against the crypto exchange. And importantly, it's an unsecured claim, which is the claim with the lowest priority within the bankruptcy code. If it is determined, or if it is in fact the case that it is the customer's property and it remains such, notwithstanding the deposit with the exchange, then the customer, in theory, should have the right to seek bankruptcy court relief and obtain relief from the automatic stay to essentially reclaim his or her crypto assets. Again, reverting back quickly to the idea of property of the estate versus the customer's property. If it's property of the estate, the customer is going to be left with an unsecured claim. It is, again, the lowest priority claim. And what we're seeing in some of these crypto cases, crypto bankruptcy cases that are happening as we speak, is these creditors / customers are looking at getting distributions on account of their claim in amounts that are far less than getting full return or full recovery on their claim. Not to be too pessimistic, but and it wouldn't be fair to say pennies on the dollar, but customers who only have unsecured claims against crypto exchanges are not expecting to get close to full recovery on their claim. It's interesting, and we'll get into a specific court case that came out of the Celsius Network bankruptcy case in a moment, but over the past couple of years, we've seen an evolution in the user agreements that these platforms have had with their customers. Two years ago, these user agreements read, well, they didn't read very well. They were riddled with ambiguities, riddled with disclosures and qualifications about what the characterization of a customer's deposit may or may not be, and really didn't provide any coherent and consistent provision within itself in which a customer could reasonably expect to have an appreciation as to how at least the exchange or platform regarded the customer's deposit, whether in fact the customer retained title or not. What we've seen over the last 2 years, in part due to pressure from regulatory agencies and in part due to sort of the maturity of the industry, is that these platforms have made substantial changes to their user agreements over the past few years and have made a more concerted effort to provide a coherent statement as to what a customer's rights may or may not be with respect to the crypto assets, which in part also turns on what type of product the customer is signing up for or is contemplating investing in, because the products themselves are different in terms of what the expectations are and should be by the parties. The Celsius network case that we're going to sort of get into a little bit more detail and discuss some of the products and some of the language in the user agreement is something that Peter had sort of previewed for us and showed. I believe that there were at least 6 or more versions of the terms of use. And that was prior to the bankruptcy case. I don't think there's been any changes since, but it gives you a sense that the terms of use were constantly evolving. And typically what would happen is a customer would get an email, or the next time it would log on, alerting them to the fact that there's been a change in the terms of use. And the customer would then acknowledge receipt, be asked to review those terms, and then generally speaking, accept those terms. And that would essentially update the user agreement that had been previously entered into. The Celsius network provided, and is, I guess you would say, an exchange as well as a lending platform. It was a platform that enabled customers to simply use it as a means for holding its cryptocurrency. In other instances, there was an opportunity for customers to earn a yield or interest or an accrual of like-kind crypto on their deposit in exchange for making it available to the exchange in order for the exchange to then use it for its own purposes. And again, to try to capture yield that would be greater than what it promised to turn a profit. And there were other programs and products, but those are the 2 that I really want to focus on, at least on the retail side, to give you a sense of the user agreements that ultimately were put in place with respect to both those products, and how those user agreements, together with other factors, are considered in determining whether we're dealing with property of the estate or property of an individual customer. Peter, could you go back to the previous slide? Okay, thank you. So the custody program, and it's all in the name, this refers to the instance where a customer deposits the cryptocurrency with the exchange for purposes of it being held and stored by the exchange. And the user agreement, at least the most recent versions of the user agreements, provided and made abundantly clear that the customers retain their right, title, and interest to the crypto assets, notwithstanding the fact that it's been deposited with the exchange, and the exchange is actually commingling like-kind crypto of these customers, notwithstanding the fact that these customers are, for all intents and purposes, retaining their interest in specific cryptocurrency assets. The fact that there has been commingling in some corners of the the industry, there's been an argument and a suggestion that the commingling, unless you're able to quickly ascertain the various crypto assets of the custodial customers, whose specific crypto is what comprises this commingling, there's a question as to whether you can readily identify a specific customer's actual asset. And that's been one of the issues that's been brought up in suggesting even assets that, pursuant to the user agreement, make it clear that the customer retains their right, title, and interest in specific crypto assets. The commingling may effectively undo that ownership expectation on the part of the customers. As I mentioned earlier, again, there's also this earned product. It's also considered or referred to as a reward product. If you're looking at other platforms, such as Voyager, they refer to their interest yield opportunities as a reward program. And in the case of Celsius, which we're talking about here, it's expressly provided in the user agreement that the customers are in fact granting all of their right, title, and interest to the exchange and effectively walking away from any title to those assets in exchange for the opportunity to earn yield on these cryptocurrency deposits. And those folks obviously have to contend with the fact that the user agreement, as the bankruptcy court in Celsius ultimately concluded, is by far the most important consideration in determining whether or not the crypto assets at issue are property of the estate versus property of the customer. Not surprisingly, in the bankruptcy case, in the Celsius bankruptcy case, notwithstanding the terms of the user agreement and notwithstanding the fact that there was no real way to contend or suggest that the user agreement was ambiguous or not clear on this issue, customers and various state regulatory agencies objected to the efforts by the debtor Celsius network to have a determination by the court that these crypto assets are and should be regarded as property of the bankruptcy estate, noting and arguing, among other things, that Celsius and its officers were out there publicly making statements which suggested perhaps that the cryptocurrency assets under these earn reward programs remained assets of the customers. The court dismissed that, said it was irrelevant, essentially. Customers and the state regulatory agencies contended that the terms of the user agreements themselves were simply unconscionable or should be regarded as unenforceable as a clip-wrap agreement under New York law. As Peter sort of laid out for us earlier, surprisingly, perhaps, these clip-wrap agreements are generally upheld and not just in New York. You would get virtually the same result under California and Delaware law. And the state regulatory agencies also contended that these EARN programs violated state securities laws, which prohibit the marketing and sale of unregistered securities. And again, while the court recognized that could be an issue and that indeed individual customers may have defenses to whether or not the contract, in this case, the user agreement, is binding upon them, specifically, uniquely to one particular customer, in the main, none of these issues, and to the point as to any violation of a state security law, none of that impacted the court's determination that the the EARN deposits were in fact property of the bankruptcy estate. And I realize I'm not getting this nearly as quickly as I need to. This is a really interesting issue that I'll quickly turn to, and hopefully I'll at least have some opportunity to hit the other agenda items, but I don't want to steal any of Brian's time, he has a lot of really interesting things as well to lay out and discuss with us. There's another interesting issue that's percolating that hasn't quite yet sort of bubbled to the surface as far as I've been able to see in these crypto bankruptcy cases, and that is, in certain instances, customers who have claims arising out of the rescission of a purchase or sale of a security may find that their claim is subordinated. Well, what's a security? That's another great question, and we're not quite yet sure how things like an EARN account may be regarded, but there is certainly authority out there, and the regulatory agencies are certainly taking the position that an EARN account is essentially an investment contract subject to securities registration, and as a result, if someone were to bring a claim arising out of the sale or purchase of an EARN account, it may be that that claim is subordinated to the claim of all other creditors, whether it's a customer or otherwise. And so it's a really interesting issue that certainly is going to be the subject of academic debate, certainly, and I suspect as we get closer to plan confirmation in some of these older cryptocurrency bankruptcy cases, you might see this issue being brought up in that context as well. Because ultimately, a lot of these issues are about customers with claims against the debtor who are jockeying for relative priority over one another because there's only so much value at the end of the day to be distributed to customers and creditors generally.
All right, Jonathan, does that...
We're going to have to skip preferences, unfortunately, but I think the important thing to recognize is that there are a lot of open issues as it relates to preference law and how it's going to be applied in the cryptocurrency bankruptcy space. There are some tremendously interesting and likely effective affirmative defenses, but we're going to have to cut it off there, and we'll have to revisit that some other time. Brian?
Yeah, we can certainly circulate the slides to anyone that's interested, so at least you have some of the issues that Jonathan didn't get to cover this afternoon. So in the next 15 minutes, what I'm going to do is just walk us through briefly some of the pending legislation and some of the changes that are coming up to the Uniform Commercial Code. The pending legislation was both at a federal and state level. They were all in the last Congress, obviously, and they are going to have to be reintroduced into this Congress. But I think the relevance of this is that it really highlights what we are likely to see. It may not be exactly along these exact terms, but there does seem to be a confluence of the legislation trying to achieve a particular result, which is obviously some form of regulation of what is currently a Wild West industry. So, Peter, if you can just flip the slide, please. So the first statute that was in the last Congress was in June 2022. There was the Responsible Financial Innovation Act, which was promoted, sponsored by the senators of both New York and Wyoming, which are two leading states in the world of crypto. They have gone out of their way to try and be host states for different crypto exchanges. But so some of the things that we see that are in this legislation are common to what we've seen in other legislation that's pending. One is it creates a standard for determining what is a digital asset. There's really no current definition. When we get to Article 8 and Article 12 of the UCC, that also defines it. It tries to determine what is a digital asset by really looking at what is the purpose of the asset really. Is it a store of value or is it a means of an exchange? And it tries to create some common definitions. The statute also would have defined the requirements for stable coins. And you heard Peter talk earlier about what stable coins are. Again, if you're using a stable coin, ideally you should have some comfort that it is pegged one-to-one to whatever the fiat currency is, or to whatever it is being pegged to. Obviously, that didn't happen to Terra, and so that's created a major issue in the industry. But this statute would have created legislation as to what are the requirements for stable coins, including that they be backed by 100% reserves of US dollars, that there be certain disclosure requirements. It also proposed to set up a process for banks to issue stable coins. Stable coins can and might become a very viable payment methodology other than using payment on your credit cards. It does represent a form of transaction currency that is not yet widely accepted, but if there is some regulation behind it, maybe it will become widely accepted. And the intention, again, of the statute was to create some kind of SRO, a self-regulatory organization, much like you have in the securities industry, so that there would be some kind of internal discipline for the issuance of stablecoins. The next statute was Senate Bill 4760, which was called the Digital Commodities Consumer Protection Act. And this came out of the Agriculture Subcommittee. And as you folks probably know, anyone who's been watching this industry at all, you know that there is a tussle between the SEC and the CFTC, the Commodities Future Trading Commission, regarding whether or not digital currencies are more in the nature of commodities or are they securities. It does seem that it's heading towards the commodity direction. Certainly the industry would rather see it head in that direction. But Gary Gensler, who, as you know, is the chairman of the SEC, has said otherwise. He believes that many of these different tokens and coins out there are in fact securities. It remains to be seen how that all shakes out. But under this Digital Commodities Consumer Protection Act, again, it would define a digital commodity. Again, looking at it in the way that the digital asset works, what's it used for? Does it act like a commodity? Does it act like a medium of exchange? Does it act like a store of value? So that would be part of the analysis in determining under the statute what it, whether it would be a commodity subject to regulation by the CFTC. And then, you know, similar to the prior legislation, again, it would require all players in this industry to register, to engage in record-keeping requirements and risk management requirements. Then the next statute is the Digital Assets Anti-Money Laundering Act. Obviously, the regulators are interested not only in regulating how the industry is used, but importantly, that it's not used for illicit purposes. And so this legislation, which was introduced by Senator Warren, the purpose of this legislation would have been to require that digital asset providers comply with the Bank Secrecy Act and all the other elements that go along when you're a banker, know your customer requirements, and various other bank regulatory requirements. Then at a more regulatory level, FinCEN, the Financial Crimes Enforcement Network, which has become much more important over the last few years, they are also proposing regulatory mandates that require reporting requirements and that require providers of wallets which are not hosted, in other words, exchanges which are not hosting the wallets, that they're also requiring various KYC requirements. So again, you can see that there's a confluence of what this legislation is looking to do. So too, the Treasury Department is looking to pretty much the same thing, requiring that the service providers in what are called VASPs, Virtual Asset Service Providers, yet another acronym in this area, follows the bank secrecy requirements. So that's what's going on at in a very broad brush at a federal level. At a state level, Governor Newsom issued an executive order in May last year, and the purpose of that was to mandate that California state agencies report back to the governor on how to harmonize federal and state legislation in this area, and how legislation is going to affect many other matters that are of consequence to us: energy, climate, illicit activity. So it was really a mandate to state agencies to investigate and report back. There was a statute, or I should say there was a bill that was introduced into the California legislature called the Digital Financial Assets Law. And that bill would have required that all companies that are engaging in digital financial assets register with the State Department of Financial Protection and Innovation, the DPFI, which is a roll-up, as you may know, of certain other agencies that existed within the state framework before. That was vetoed by the governor in the third quarter of last year. The governor felt it was just a little too far ahead and felt that there needed to be more development of the thinking on it before that came into being. As you may know, most crypto exchanges are required to register under money transfer regulations in whatever jurisdiction that they're operating in. But it does appear, based upon the equivalent of a private letter ruling that the DPFI issued last year, that at least as of last year, based upon the facts of that case, which were pretty typical of what a digital exchange does, that the DPFI did not exert jurisdiction over digital exchanges. That I expect will change certainly with legislation, but that's the current status of the law in California. So now I'm just going to spend a few minutes on the changes to the upcoming changes to the Uniform Commercial Code. So the intention behind the drafters was to harmonize the various provisions of the Uniform Commercial Code with what is an entirely new asset class that, of course, did not exist until a few years ago. So the way that that's being proposed is both to amend certain provisions of the existing Uniform Commercial Code, in particular Article 3, 8, and 9, and the one that we're going to deal with primarily is Article 9, and then also to introduce an entirely new article, Article 12, which is intended to deal with digital assets. The changes have been finalized. They have been sent out to the states, and this slide indicates the various states into which these changes have been introduced. They have not, of course, become law. I don't think it's become law in any state yet, and they are all in different states of adoption, whether there's been a first reading, a second reading, passed out of their judiciary committee, or whatever the process is internally within the given state. In California, I saw most recently that there'd been a first reading of the proposed changes. But the intention, of course, is like the rest of the Uniform Commercial Code, it is intended to become adopted by all states within the Union. So Article 8 currently deals with contractual relationships if an account is a custodial type account. So the key issue here, we've been talking a lot about what these user agreements say. And one of the things that one should look at in these user agreements, either if you're signing up for one, or if you're looking at it on behalf of a client, is whether or not the user agreement adopts Article 8. Because if it adopts the existing Article 8 will segregate, will require the segregation of the assets and make them custodial. So as the slide points out, Section 8503 provides that a financial asset on an exchange is owned by the customer. If it is in a securities intermediary, of course, we're not dealing with securities here, but again, if the exchange adopts this will apply if it's in the customer agreement. So first, it's got to be agreed to by the particular exchange. They've got to treat it as this financial asset, and they've got to credit your account with it. If in fact they do those things, then whether or not the digital currency is commingled, assuming that they've adopted Article 8, it should still remain the customer property. And of course, if it's customer property, it doesn't necessarily mean in a bankruptcy case that you're going to get 100% back. But what it does mean, of course, is that you're going to share only with the customers. You're not going to share with the general unsecured creditors of that particular exchange if it were to go into a bankruptcy. Moving on to Article 9. Article 9 currently just does not deal with this effectively. We know, certainly the secure transactions lawyers and the bankruptcy lawyers know that in order to obtain a security interest under Article 9, there's two things that need to happen. First, the security interest needs to attach. In other words, you need to have a security agreement that describes the collateral, and then it needs to be perfected. The problem, of course, is how to describe this collateral and how to perfect it, issues which actually have not yet been resolved. So as to the attachment, the question is, what do you call it? What are we going to call these digital assets? Is it money? Is it a deposit account? Is it investment property? Or is it a general intangible? It likely is going to default to be a general intangible because money is a medium of exchange that is recognized by a government entity. And in fact, the proposed changes to the UCC make it very clear that it will not be regarded as money on an exchange until and unless it has been adopted by the government as a means of exchange. So for the most part, these exchanges will never get to that level. It's not going to be a deposit account because under Article 9, a deposit account means something deposited with a bank. And here it's all decentralized. There is no bank, so it can't be a deposit account. For a variety of reasons, it won't be investment property, and thus it's likely to default as to a general intangible. So how do we secure a general intangible? Typically what you do is you file a UCC-1. That is not an ideal way, however, to secure a security interest in a digital asset, but it is currently likely the primary way to perfect it as Article 9 exists now. So what Article 9 will be amended to show is it's going to create this new type of asset class called the CER, a controllable electronic record. And the new Article 9.105 will be very similar to Article 12. So what I'm saying in connection with Article 9 will be applicable in Article 12 with some very minor modifications, basically giving you the methodology on how to get a security interest in a CER. And bottom line, what it means is that, going back to what Peter said, you need to get the control of the private key. If you have control of the private key, then you can get a security interest in a CER under Article 9. And then, as I say, and we're at the end of the hour, under Article 12, the same methodology is applied. And Article 12 will also provide a methodology for being able to trade these CERs much in the same way as you could a negotiable instrument. So I know we've packed a lot into this hour. There is, of course, a lot of stuff here. I hope it was useful to everybody. I hope that the bankruptcy lawyers learned a little about intangibles and crypto, and I hope the crypto people on the phone learned a little about bankruptcy. So much appreciated, everybody. We will send out to you the CLE information, and to the extent anybody would like to have a copy of these slides, we're happy to share those with you as well. Thank you so much.